Hey, federal family, we just got the Department of Education ruling on layoffs in allowing layoffs to continue as the case plays out. Please double tap to get this out and share this widely. Every federal employee who's concerned about layoffs or just in general about what's happening in the federal government and anyone who cares about public schools needs to see this today. So about the decision, right, here's my initial take. The decision says nothing about why the Supreme Court allowed the layoffs to continue, which is one of the problems of the shadow docket system. That said, I've reviewed the brief order and lengthy dissent and want to explain what, if anything, this means. So right now I'm providing the bottom line up front. Then later in this video, I'll continue into the weeds. So the bottom line up front is I do not think the Supreme Court's saying anything here about whether the layoffs are legal or not, but they are signaling indirectly they are okay with layoffs proceeding while the legal system sorts it out. The liberals disagree, more clearly seeing the harm. Again, I think it would have been easy for the Supreme Court in either case to say they thought the layoffs would be likely to be found legal. They did not say that, probably normally wouldn't have said it here, but would have said it in the other decision. So what I do think they have indicated, though, in both decisions is that the conservatives are okay with thousands of people being laid off while we look into it through the legal system. But again, they don't explain their reasoning, so I am just guessing like the rest of America. All right, so that's the bottom line up front. Here are the weeds, right? I just read the Supreme Court's brand new shadow docket order in McMahon versus New York, and here's the straight talk breakdown you won't get anywhere else. So first of all, looking into the weeds, what did the court do? Well, in a one-paragraph unsigned order, the majority hit the pause button on a lower court injunction that had forced the Department of Education to bring back the 1,378 employees it fired in March. No explanation for the majority, right? Just silence. Justice Sotomayor, joined by Justices Kagan and Jackson, the liberals, filed a 19-page dissent blasting the move. So why is the dissent such a bombshell? Well, Sotomayor reminds us that Congress, not the president, creates and can abolish cabinet agencies. The president's job is to faithfully execute the laws, not scrap them. Her words, the decision hands the executive the power to repeal statutes by firing all those necessary to carry them out. Dang. So what's the factual backdrop? Well, Secretary Linda McMahon, acting on President Trump's order to put herself out of a job, cut over half of the department's workforce overnight. The exact first step, she said, towards shuttering the agency. The mass firing gutted offices that run student aid, civil rights enforcement, and special education programs. The department is very popular. The administration's actions very unpopular. The constitutional stakes? Well, when the executive fires everyone who makes a statute work, it's effectively repealing the statute without a single vote in Congress. Sotomayor calls out that direct hit on separation of powers, and she reminds us again that only Congress can abolish the department. The president can't do it by pink slip. So how does this connect to last week's Trump versus AFGE stay? Well, there the court, 8-1, let the White House broader layoff playbook go forward while claiming it wasn't ruling on the merits, just the executive order of the president. Today's Education Department stay sends the same signal that this majority will not stand in the way of large-scale workforce cuts, even when the record indicates the statutory missions could collapse. Sotomayor explicitly makes the case that this is constitutionally concerning. So what are the practical takeaways for federal employees? If you are one of the education employees reinstated by the district judge, you're back in limbo, off payroll for months, maybe years, likely assuming they're going to move forward with it, which they will, I think. Other agencies eyeing layoffs got a green light to roll the dice, but it's still a mixed bag, and they are and should continue to be nervous. The Supreme Court has not issued any language about whether the layoffs are likely to be lawful. I've seen many indications that they very well might not be. The court hasn't ruled the firings legal, and it's raised the bar for anyone asking a judge to stop them early. Bottom line, 2 stays in 2 weeks means the conservative majority is comfortable laying, people off and proceeding first, arguing legality later. If Congress doesn't step in, expect more agency by agency attrition wars. They won't likely step in, given they're controlled by conservatives. In a moment, I'm going to do a second post on this where I do something different than I've ever done before. I'm usually just trying to break down things for you, but in this new post, I'm going to share my personal thoughts about why the dissent is correct in this case, why I'm personally concerned about it, how it motivates me, and when this case comes back to the Supreme Court, I'm hopeful and would like to see a different result. I still think that possibility is open, but I think that we're hearing the Supreme Court's okay deciding that fact after the layoffs have occurred. Thank you, everybody, for your support. Please share this, and I hope you have a great day.